In the 1920s and 1930s, there were a great number of small-scale, privately run newspapers in the USA. This was the era of the muckraker newspaper, which sought to uncover corruption in government, and of yellow journalism, which maliciously attacked people who didn't deserve it. Often it was hard to tell the two apart, depending on your political leanings. Sound familiar? In 1925, Minnesota passed legislation which was intended to prohibit yellow journalism or malicious muckraking. It said that people were guilty of a nuisance if they were involved in a malicious, scandalous and defamatory newspaper, magazine or other periodical. J. Neer was the publisher of the Saturday Press in Minneapolis, Minnesota. It was proudly malicious, scandalous and defamatory. The Supreme Court described it this way: the articles charged in substance that a Jewish gangster was in control of gambling, bootlegging and racketeering in Minneapolis, and that law enforcing officers and agencies were not energetically performing their duties. Most of the charges were directed against the chief of police. He was charged with gross neglect of duty, illicit relations with gangsters, and with participation in graft. The governor of Minnesota filed a complaint and obtained a court injunction preventing Neer from continuing to publish the Saturday Press because it breached the Minnesota law. Neer challenged that decision and the dispute ended up before the Supreme Court. Neer argued that the First Amendment, which by the 14th Amendment applied to the states, prohibited governments from prior restraint on a publication. In other words, if a newspaper was defamatory, then the person defamed could seek redress, but only afterwards. Newspapers couldn't constitutionally be prevented from saying things in the first place, regardless of how malicious they might be. The court agreed, quoting the great James Madison, who said, "It is better to leave a few of its noxious branches to their luxuriant growth than, by pruning them away, to injure the vigour of those yielding the proper fruits. And can the wisdom of this policy be doubted by any who reflect that to the press alone, checkered as it is with abuses, the world is indebted for all the triumphs which have been gained by reason and humanity over error and oppression?" Setting aside a few extreme exceptions, prior restraint by a government upon a publisher breaches that publisher's First Amendment rights. Redress comes after publication, not before.